Hello everyone. Welcome to the Investor Education Series from the Pakistan Institute of Corporate Governance. My name is Talha bin Hamid. I'm working as the Head of Director and Training Development at the PICG. Today, we are going to learn about director selection. How is a director selected? The first step is to identify a capability gap. The second is to develop a search plan for the board. Third is to get to know the person and select the best qualified, most suitable candidate. The fourth is recommend the candidate for the election at the general meeting. And finally, the fifth step is the election process. These steps are usually performed by the board's nomination committee. When selecting a director, what are some of the skills, experience, and attributes that are desirable to be present? They should be honest, they should have integrity, they should have good reputation, they should have excellent communication skills, they should have emotional intelligence, and they should cover the entire spectrum of EQ. They should have the interest of minority shareholders as a top priority. They should have financial, legal, or functional or technical expertise depending upon the precise slot that needs to be filled. They should also have a journal management and business expertise. They should have relevant industry experience, and they should have interest of all shareholders and stakeholders at the top of their priorities. In addition to all that, a director position also requires people skills. They should be able to express themselves and they should be good listeners. They should deal with others with respect and as equals. They should be collaborative and they should act as elder statesmen because once these values are inculcated at the very top of a company's hierarchy, they will become the culture of the organization. They should be honest, they should be truthful, they should do what's right for the company rather than protecting self interest or relationship, and they should have the courage to say no. They should have a good commercial and business instinct. They should have good business judgment. They should have not just intelligence, but emotional intelligence. They should have street smarts and they should have commercial acumen. The minimum eligibility of a director is graduation, and they must have management business experience of at least 5 years at a senior level in an active capacity. As per Section 153 of Companies Act, certain individuals are barred from becoming directors. First, if they are minors, that means they are below 18 years of age, they are of unsound mind, they have been convicted by a court of law for an offense involving moral turpitude, or they are in the business of brokerage pertaining to securities market or the future market, or are the spouse of any person associated in these businesses, because all these attributes compromise the ability of a director to act in the best interest of the company. In addition to the previous reasons to bar a person from becoming a director, a person not holding a national tax number is also barred from becoming a director. A person is required to be a member to be eligible. That means that they should have a certain amount of shares in the company in order to become a director. And a person who has been declared by the court of competent jurisdiction as a defaulter in the repayment of a loan, they're also ineligible to become a director. Now, how many companies a person can be a director of? As for Section 155, the number is restricted to 7. That means that a director cannot hold office of a director for more than 7 companies. How does a director depart? They can resign, or they can be removed by resolution at the general meeting by the shareholders. Because remember, shareholders are the ones that appoint a director, so they have the authority to remove a director. Or if they're absent from 3 consecutive board meetings or from all the meetings for a continuous period of 3 months, whichever is longer, without leave of absence. In that case, too, they are removed from that. In addition to the scenarios discussed earlier, a director shall also cease to hold office if they or a company in which they're a director or a firm in which they're a partner becomes an office holder in the company in question. That is anything other than chief executive or a legal advisor or technical advisor. And especially if it happens without the prior sanction of the company in question, that means that they instantly cease to hold office. Similarly, if they accept a loan or guarantee from the company in contravention of Section 182, that also makes them ineligible to continue as a director. In conclusion, we know what makes for a good director and what are the situations which may result in directors ceasing to hold office. We believe that we should be on the lookout, either as directors ourselves or shareholders appointing directors, that the directors that we elect continue to discharge their duties with diligence, integrity, and honesty. Thank you.